Welcome back to the Making International Love video series. In this video, I'll be explaining to you on National Human Rights Commission. In year 2001, the National Human Rights Commission of Korea was established as a national institution for human rights protection. According to Article 1 of the National Human Rights Commission Act, the mandate of the Commission is to contribute to the embodiment of the human dignity and worth and development of democracy by ensuring the protection and promotion of inviolable and fundamental human rights of all individuals. In its concluding observations in year 2006, the Human Rights Committee under the International Covenant on Civil Political Rights welcomed the establishment of this commission, saying that it was set up in conformity with the standard of the Paris principles relating to the status of national institutions for promotion and protection of human rights, which was adopted in 1993 by the General Assembly Resolution 48-134. According to the principles, the national institutions shall be vested with the competence to promote and protect human rights and given as broad a mandate as possible by a constitution or an act. The Commission is composed of the 11 commissioners, including 1 president and 3 standing commissioners. 4 members are selected by the National Assembly and the President, respectively, while the Supreme Court, the Chief Justice, selects 3 more members. The President's Commission is allowed to speak at the National Assembly and the Cabinet meetings of the administrative branch. To facilitate an effective administration, the Commission set up the Plenary Committee, a Standing Committee, and several committees dealing with human rights violations and child rights, discrimination remedy, and the right of persons with disabilities. It also has regional offices. The mandates and functions of the Commission include developing human rights policies through conducting human rights research and issuing policy recommendations, investigating discrimination and human rights violations, and providing access to remedies. The functions also include promoting human rights education and raising public awareness of human rights, the monitoring international implementation of international human rights treaties, and cooperating with government agencies and civil organizations and UN human rights bodies and national human rights institutions. The Commission has recommended critical policies regarding human rights, including opinions on the elimination of capital punishment in 2005, under recognition of the rights of the Conscientious Objection, and introduction of alternative services to military duties in 2005. In 2005, it announced that the National Action Plans for the Promotion and Protection of Human Rights and recommended the enactment of Anti-Discrimination Act in 2006. Legally speaking, the Commission is an independent agency separated from the legislature, executive, or the judicial branches of the government. The Commission's structure, the personnel and finance, however, are controlled by the executive branch. As such, the Commission's independence is likely to be threatened structurally. In fact, the independence of the Commission was severely threatened during the conservative administration. Many Commission members were not familiar with or even hostile to human rights. In 2009, the personnel of Commission were curtailed by up to 20% after failed attempt to change its status under the President. In its concrete observation in 2015, the Human Rights Committee recommended that Korea should adopt legislation to secure a fully transparent and participatory process for the selection and appointment of its members. The transparent and participatory process for the selection of appointment of its members is strongly recommended by the Human Rights Committee at the time. Additionally, the Committee Against Torture, in its concluding observation in 2017, recommended, in particular, that the Korea establish an independent committee to nominate candidates and to guarantee the independence, diversity, and functional immunity of members of the Commission, provide the Commission with adequate human and financial resources. The Commission regained its A status in 2016 from the International Coordinating Committee of National Human Rights Institutions for the Promotion Protection of Human Rights, which belonged to the ICC, after risking failing into the B status for the several years due to its lack of independence. Let me touch upon one of the most interesting case, also most serious case of the human rights violation in the history in Korea, which is a conscientious objection. General comment 22nd by the Human Rights Committee concerning the rights to freedom of thought, conscience, and religion observed that the right to refuse to perform the military service can be derived from the Article 18 of the International Covenants for Civil Political Rights if the obligation to use legal force may seriously conflict with freedom of conscience and the right to manifest its own religion or belief. As of 2018, the South Korean young men are required to actively serve in the military for 21 to 24 months and to be listed in reserve forces for further several years. According to Article 88 of the Korean Military Service Law, anyone who refuses to serve in the military without a reasonable cause may face up to 3 years of imprisonment. Korean conscientious objections have been typically sentenced to 1.5 years of imprisonment. Between 1950 and the end of 2016, around 18,800 Korean young men were punished due to the conscientious objection. Most of them are believers or Jehovah's Witnesses. As of 2012, the number of all the conscientious objectors around the world is 723, and among them, Korea's are the 669, accounting to 92.5%. In 2011, Korean Constitutional Court held that the law does not violate the rights of the conscience. The alleged reason that the Korean government does not recognize conscientious objection by adopting the alternative to military service is a military threat from the North Korea. In 2007, under the liberal President Roh Moo-hyun, the Defense Ministry had proposed a plan that conscientious objector could choose an alternative to military service in the field of social service. Afterward, however, two conservative presidents, Lee and Park, considered the plan, citing that the popular consensus was not existent. In general, the public opinion in Korea is against allowing the conscientious objection. The Human Rights Committee pointed out that the law violates the rights to conscience and religion. Until 2018, several hundred Korean conscientious objectors has brought their cases through individual communications process to the committee since the 2000s. Responding to their calls, the committee has recommended the Korean government to provide an effective and enforceable remedy to them. In the concluding observations on the fourth periodic report, the committee demanded Korea that it immediately release all conscientious objectors and expunge their criminal records. It also demanded Korea that the adequate compensation and alternative service of the civilian nature must be provided to them. Since 2016, the Korean law courts have been increasingly finding conscientious objectors not guilty. The first case in which conscientious objectors were found not to be guilty was Lander 204. Until 2018, 83 cases, including district and appellate cases, where conscientious objections were declared to be not guilty, have been reported. In one case, a district court held that everyone has the obligation of national defense. Not going to a battlefield with a weapon is not only way to protect the country, and there are other ways to serve the country. The Supreme Court and the concerned courts, however, stick to the conclusion that they should be punished by the law. In 2017, the Korean National Human Rights Commission recommended to the Defense Minister and the National Assembly Speaker that alternative to mandatory military service should be introduced. In June 2018, the concerned court held that the Korean law that did not recognize the conscientious objection was not consistent with the Constitution, paving the way to recognizing. According to the ruling, the National Assembly introduced the alternate service to military service.